let's go.
Yes, I would like rebuttal. So
What?
Yes.
You can get up to 5 minutes. In other words, you're going to talk first, tell us what you think we should hear. They're going to respond, tell us what they think we should hear. Then you can get up and say, well, that's not right, or that is right, or I don't want to say anything else. Your option, okay?
Yes.
So just introduce yourself and then tell me how much time you would like for rebuttal.
My name is Christina Alexander, and I would like 5 minutes for rebuttal.
Okay. You got it.
In this matter, I would like to bring before the court the question of setting a dangerous precedent. Federal laws and state statutes uphold the payment of child support, as is a strong public policy in favor of payment of child support regardless of circumstances. So, this honorable court has upheld child support orders in this case in the past, and there is a strong public policy in support of child support orders that are valid being honored. So if this precedent is set and this case is not vacated, this order is not vacated, it may set a precedent that weakens overall public policy and rule of law in favor of payment of child support on valid support orders. I would just like to make that point first off. As I do think federal and state codes in this case that I have indicated in my briefs do support the valid orders. And in addition, I would like to bring up that the S&T in this case does benefit from federal protection and IRS code under the concept of being a tax-free entity. And IRS code, nonetheless, does support U.S. code and federal statutes in supporting payment of child support on valid support orders, including garnishment of distributions once they leave any corpus of any trust. As partner to IRS code, the S&T enjoys the protections, not just of federal law, but of state statutes. It should also not, in a capricious manner, decide arbitrarily not to pay child support while following all the other state statutes and codes, when Mr. Harris himself, as a father, would like his child supported. This is not in any way adversarial to Mr. Harris, who during his majority and during the time of capacity that was never questioned was the settler of this trust. By definition, the settler of this trust, as has been outlined in my briefs. So, like every other entity that enjoys federal benefits, benefits under IRS code, benefits of state statutes, they should follow accordingly all the other provisions provided by law and also valid orders. So regarding to garnishment, the garnishment is allowed under federal and state statutes. And I am not aware of any entities, public or private, that do not comply or are not any obligation to comply with federal law or state statutes or valid court orders, especially child support in this case. So I do not see how discretion can somehow override existent and valid court orders, statutes, and federal codes, including IRS codes. And if discretion is allowed to somehow override all these controlling bodies and entities, it would set a precedent that would weaken not just valid support orders, child support orders, but indeed the rule of law itself, subject to discretion, would weaken the codes. Child support as an exception creditor, right? This is supported by Florida statute. And as outlined in my brief, the S&T clauses are unenforceable against exception creditors, which do include child support orders, valid child support orders. As far as the welfare of Mr. Harris is a loving father. He wants the best for his child, and I'm here really to advocate for the child and for Mr. Harris as a father. There are already legal safeguards to ensure that Mr. Harris's welfare are provided for by the S&T. There does not need to be extra safeguards. They're already in place. The S&T must follow DCF guidelines as a governing body or ruling body over the S&T, and also over Medicaid guidelines. So there are already legal safeguards in place subject to criteria and standards, right, set by the ADAs, set for the S&T. So I do not see how a discretionary decision by a trustee can somehow supersede or alter codes, statutes, valid orders, legal definitions in this case. And regarding child support, an exception creditor under Florida statutes, which have been outlined in my briefs, they do allow for garnishment once a distribution does leave the corpus of the trust. It is not, therefore, technically a distribution by the trustee. By definition, Mr. Harris was the settlor of the trust, according to U.S. Code and Florida statute. And so garnishment is strongly supported in public policy and code, in IRS code and state statute, and according to other statutes that I've outlined in my brief, spendthrift clauses are unenforceable against child support. And this is also supported by case law, Bacardi v. White, Berlinger v. Castleberry, which was upheld by this court, including the valid child support orders have been upheld by this court. The garnishment of discretionary distributions supported by once they leave the corpus of the trust. Now, as far as Mr. Harris and his unfortunate disability, right, that nonetheless precludes the child from receiving court-ordered, valid child support. And Mr. Harris is not in any way adversarial to this. At the heart of this is a child that is rightfully entitled to court-ordered, valid child support. And there's no, I can find no reason why a discretionary clause somehow would supersede laws, statutes, and valid orders in this case.
Okay. Just so you know, we've read the briefs, we're familiar with the law, and you don't have to use all of your time, but if you had more to say, you could say it now, or you could save it for rebuttal. Are you okay?
Yes.
All right, so I'm going to give them a turn unless you want to add some things.
I will make notes and add
You want
accordingly.
to keep going?
No, sir. Afterwards, may I do that?
Pardon?
May I do so as part of the rebuttal?
Yes, I'm going to give you the 5 minutes you asked for.
Yes, thank you.
Nope, not a problem. Have a seat, relax. All right, your turn.
Good morning, Your Honors. What a way to start the morning earlier.
Well, sorry about that.
Certainly understandable. Troy Andrews here on behalf of the guardian for Mr. Harris. Along with me is seated at the table is Mr. John Staunton. This decision should be PCA'd both on procedural ground and substantive grounds. I'll try to cover want to go into the facts a little bit and some procedural issues, and then go into what I understand her substantive arguments are. I think she may have conceded one here during argument. Not sure. Want to be mindful of the court's time. The facts here: it's undisputed that Mr. Harris was burned in a car fire. Both of his legs were burned off.
Yeah, you don't need to tell us the facts.
Thank you. It's undisputed that action was settled by the mother for Cliff Harris, and that money was placed directly into a special needs trust. The annuity funded the special needs trust.
You make an allegation, I think, in the brief, that if the child support was paid, the special needs trust would be wiped out? It's generating income, correct, as we speak?
It's generating a little bit of income, Your Honor.
Okay.
But it would be at that time, and if the support arrearage was awarded, it would wipe out the trust. Yes, that's what the court found out.
What about if the judge ordered X amount that would keep the trust alive, but wouldn't deplete it, but would still pay something towards child support?
I don't believe that you're asking mathematically. I don't.
Well, it's a hypothetical because it's based upon the income being produced. So there is some number that a judge could exercise discretion to award that would not deplete the trust. Is that correct?
I don't know that to be the case. That would have to be a factual finding. Your Honor, the facts that we're here on are over, I think, a year and a half ago. I don't want to misrepresent anything to the court.
Okay, that's fine.
Just one factual
Yes, sir.
question just wasn't clear to me from the
Yes,
brief
sir.
or the record. Is the 130-something, or I forget what the total amount is currently, that constitutes trust corpus, but is that all there ever will be, or are there continuing structured settlement payments into the trust
I believe
for the rest
that
of his natural life?
I believe that there will be some limited payments going forward in the future. I believe that. I may have to check, but I don't think that was a factual issue that was discussed in the record, Your Honor.
Well, the testimony below from Mr. Staunton was Mr. Harris will receive $3,035 for life a month.
Okay, all right. If that's what.
Well, that's the testimony below.
Okay.
And that was appealed below, and we PCA'd that.
Okay.
So what's your new issue? What's the new issue today?
I'm the appellee, Your Honor.
No, what's your new issue?
My new issue?
Mm-hmm. You're the appellant below that lost and got PCA'd on the issue of it being settled with personal injury funds. We rejected that argument. The court below found that it was income because it was in-kind payments that was reimbursed for living expenses. We rejected that argument, PCA'd that. Then you argued that this was barred by Social Security, but he's never received any Title IV payments, nor was he declared indigent, so we rejected that argument. So what's your argument for affirmance today?
Okay.
Because federal law does not appear to preempt Florida statutes.
Well, Your Honor, this special needs trust is set up for the sole benefit of Mr. Harris.
Yeah, but show me where the federal law says that if we follow 736-0503 and attach a writ of garnishment to a payment that's to his benefit, that he will lose Medicaid, because it doesn't say that.
When you say to his benefit, sir, are you talking about directly to the beneficiary, Cliff Harris, sir?
Sir, any payment on his behalf for his expenses is to his benefit.
I understand what you're saying.
You're splitting hairs.
Well,
Any payment, because there's record evidence that they pay for his cell phone, his car insurance, his travel expenses, his TVs, his stereos, everything. Are you saying that's not for his benefit, even though they pay the creditors directly?
Your Honor, that is to his benefit.
Then why isn't paying his blood child to his benefit?
Because the federal statute does not allow...
Which one?
Sir, I've cited it on page, get my glasses.
But it doesn't preempt state law, sir. And it doesn't render him ineligible. There's no language in that statute you cite that renders him ineligible. The only thing you cite is a program manual from the Social Security which clearly says that you, as an individual, are not allowed to cite that as authority to establish or create any rights. So on what basis are you, as an officer of the court, citing something that says you're not supposed to cite it as authority?
You're talking about the Palms manual?
Yes, sir.
That's persuasive authority, sir?
No, the United States Supreme Court says it's not. It has no value.
Okay.
You want me to
I
quote you
just-
the
I-
case?
If that's the case, Your Honor, I'm not.
It is
found-
the
I haven't-
case.
I haven't found that, Your Honor. I haven't found that. All I can go is the testimony by the people that run the trust and under this code, and this is the guidelines that these are the guidelines that the department operates by, Your Honor. And
136P says,
yes, sir.
if any assets are used for the benefit of the individual's child, the individual does not lose eligibility for Medicaid. You haven't cited that statute. You've cited 2D, which says that this subsection does not apply to your type of special needs trust. Well, that's not the subsection that controls here. Because assets used in a special needs trust for the benefit of the individual's child, if those payments are made to the individual's child, that individual, the guardian, Mr. Harris, does not lose Medicaid benefits. That's clearly what the statute says.
I'll have to look at that statute. I believe that was looked at thoroughly and brought by the other. I don't know if it was addressed by the other side, but I don't think it says that, Your Honor.
where in this statute that you've cited and you rely upon does it show an intent by Congress to override a state domestic relations law, such as 736-0503?
Sir, the provisions, Article 7 lists the exceptions, the enumerated exceptions.
Article 7 of the trust?
Article 7 under the U.S. Code, this is referenced on page 9 and 10 of my brief. It lists, besides the sole benefit test, that this money has to be spent for the sole benefit, it lists specific enumerated exceptions, Your Honor, on page 9 of my brief and continuing on to 10. And nowhere, Your Honor, respectfully, does it mention that child support can be paid. It does not say that, Your Honor.
Under what statute?
Your Honor, that's going to be, I believe that's under 1396P D4A, but it's also cited, in Article 7 of the S&T itself, of the document itself, Your Honor.
Yeah, but also Article 7 of the S&T also says that appropriate distributions, and I quote, appropriate distributions that can be made include expenditures for travel, companionship, whatever that means, experiences, whatever that means, and expenses in bringing the beneficiaries, Mr. Harris's siblings, and others for visitation. So what you're arguing is he can bring his girlfriend from Peru, first class, to see him in Pinellas County. The trust can make that payment, but the trust cannot make a payment for his own child.
Well, first of all, I guess that could be, respectfully, that could be an argument, but the fact is...
What else is there?
Your Honor, the facts are here in this case is that the trust has denied many requests for Mr. Harris.
That doesn't matter. We're
And
going
it's
by
on
the
sole
trust language. You're arguing the trust language, and I'm just giving it back to you.
Okay.
So
and
which
that,
is it?
And that language is directly from 1396, Your Honor.
So where in the federal statute does it say he is not required, that Congress has said expressly or impliedly that he does not have to pay child support?
It has not said it expressly, but impliedly, sir, it is not an enumerated, an exception. And these are federal statutes. There's no provision in the statute that allows for child support or alimony.
Are you familiar with the Rose versus Rose case out of the United States Supreme Court?
No, sir.
The United States Supreme Court holds that before a state law governing domestic relations will be overridden by federal law, it must do major damage to a clear and substantial federal interest. What danger does garnishing a distribution for the payment of a portion of child support do major damage to a clear and substantial federal interest?
The federal interest here is that the money has to be set aside for his sole benefit because he's receiving government benefits. And the danger also is that once, if Mr. Harris dies, this money that's in this trust has to go back to be paid to those government assistants.
In terms of equity, that money that he's withholding from his child goes back to the state. Under equity, it would appear that it would be better to send some of that to his child rather than it reverting back to the state. Would you agree with that statement? Yes or no first, and then you can explain.
No, sir. And the reason
So
why...
you can pay for all these experiences and all this companionship and all this travel of everybody under the sun, but you're arguing to me it's of no benefit that he pays for his own child, and that money, some of which should be going to his child, should go back to the state upon his death.
Your Honor, Mr. Harris is not the trustee.
Mr.
Harris
The
has...
statute makes no distinction as who the trustee is, and the statute makes no distinction as to how it was
The Federal
formed.
Trust Code statute or the U.S. Code, Your Honor?
The Florida state statute, which we are required to follow.
504 makes a distinction when there is a discretionary trust. It is undisputed that this is a discretionary trust. Mr. Harris has no control whatsoever. It's all in the hands of the trustee, Your Honor. He has absolutely no control. And this S&T was set up well before the parties met and well before this child was born. This is not something that was created...
I guess the point is, if there's a distribution to him, that would be subject to a writ of garnishment. So if the trustee were to exercise discretion and give him money for X, Y, or Z, then the mother could come in and garnish those funds. Isn't that legally permissible? Unless prohibited by the trial court order, which it is.
Yes.
But if that order were modified, then there would be an ability to seize those funds for child support. And it wouldn't be any fault of the trustee or any fault of the gentleman in question.
Well, first of all, there are no disbursements that are ever made to Mr. Harris. No disbursements that are ever made to him, period.
They're made to third parties.
Yes, sir.
And those are subject to garnishment also.
I don't believe so, Your Honor, because a
So
traditional...
you're saying it's a legal impossibility?
Yes, sir, because if you take a traditional situation, the employer is often attempted to be garnished by somebody that the employee owes. But the employer owes money to the employer, to the debtor. In this situation...
That's a legality that a trial court might be able to overcome. The real nub of this case, it seems to me, is the trustee is under the illusion that the law you have cited prevents the trustee from exercising discretion for child support. And you've cited a list of things that are authorized that wouldn't break the special needs trust, correct?
I have listed that in part, that he could lose potentially his benefits, yes, sir.
I understand. Potentiality is
Yes, sir.
different from reality. We don't know the reality. And it seems to me if there's a court order covering the reality, that I don't see how the trust would be set aside by some federal law that doesn't trump state law. The other question in my mind is the list of potentially approvable or permissible expenses, is it exclusive, limited to that list, or is it non-exclusive where other things could be deemed eligible?
Your Honor,
Or is there no answer to that?
Your Honor, what we are guided by under the federal statute is that it has to go to the sole benefit of Mr. Harris, to the sole benefit.
Well,
Okay.
that's a
Why
term,
isn't the
a term of art.
satisfaction of an obligation that Mr. Harris is required by court order to pay to his sole benefit?
That issue was not raised, but to answer your question directly, Your Honor, is that Mr. Harris, unlike the child that will reach majority, does not have any other means of support, period. Because of his disabilities, he's unable to work. These are his only means of support, and Medicare and SSI does not cover everything. It only covers some things. This has to be...
Listen, I understand
Yes,
that,
sir?
don't get me wrong, I understand the competing equities with respect to how trust distributions should be allocated. My question is different.
Yes, sir?
Which is, listen, there is a judgment that requires Mr. Harris to pay child support. It is an obligation he owes. He might not otherwise be able to pay it, but were he able to, I mean, in other words, were somebody able to pay it for him? Why is that not to his sole benefit? It is the satisfaction of an obligation that law requires him to satisfy.
It doesn't go to his own well-being, Your Honor. This money is tasked for his well-being. That when the statute was cited earlier...
Time out there. This gentleman is in favor of the distribution, so his well-being says, I want to pay this. I'm the father.
Your Honor, that was...
How do you get around that aspect?
Well, Your Honor, two things. That statement was never in the record. It's not in this record.
Well, I read it in the briefs.
Okay, well, it's not in this record, and I could not object to everything, Your Honor. But I will agree that Mr. Harris loves his child and he wants to do the best things for it. The judge recognized that. The judge recognized that fact. But Mr. Harris is also currently and mentally incompetent.
Well, that's a different, that's a separate question.
This money needs to be set aside for his future well-being, which is uncertain at this time, okay, for his benefit, for his sole benefit underneath this statute.
Let me help you on your time situation. You're down to about 2.5 minutes.
Yes, sir.
And so if we've interrupted your train of thought, please get back on course and finish up in 2.5 minutes.
Except that I'm going to ask you a question, which is, it was not clear to me from your brief, I mean, your brief argues the federal law very heavy on the question of invasion of trust corpus.
Which I understand that she's dropped, Your Honor, from her argument this morning.
Right, so my question to you is, do you maintain the position that Mr. Harris's eligibility for federal SSI or Medicaid benefits are jeopardized by the garnishment of trust distributions to third parties for Mr. Harris's benefit? And if so, where in the federal act do I look to see that jeopardizing?
Your Honor, if the corpus argument is conceded, and that's something I tried to address in my brief, I don't know of a provision in the federal statute that says that if the funds are garnished, that it will jeopardize his Medicare or Medicaid and SSI eligibility. I have not read that, Your Honor.
Okay.
So I don't see that, Your Honor. However, the disbursements here, there's no disbursements to Mr. Harris, and the cases...
You've already said that, and you're down to a minute. I can't let you go over.
Your Honor, I'd like to have a little bit extra time.
Well, the law doesn't make a distinction as to the disbursements being made to a third party to the beneficiary when it comes to a child support order or a spousal support order, sir. Plus, you keep talking about the spouse or the child being a creditor. They're not referred to as a creditor in any way. They're distinguished from a judgment creditor, as expressed in the statute. So a spouse or a dependent child is not a creditor in the eyes of the law. I know the reptile section has called them exception creditors, but if you do a Westlaw search, there's not one case in the state of Florida that calls anybody an exception creditor. So let's just clear the air here. A spouse and a dependent child is not a creditor. The U.S. Supreme Court even calls it a moral obligation.
I understand all that, Your Honor, and I understand what the statute said and what the statutes said, Your Honor. And this is what we can argue about.
I'm going to give you 30 seconds to wrap up since you're out of time, okay?
Yes.
Go ahead.
The equities were appropriately balanced here. This is a unique case. Bacardi was a spendthrift trust and was not a discretionary trust.
Those disbursements were going to third parties also, sir.
Your Honor, respectfully, I don't read that in Bacardi. Respectfully, Your Honor, I don't see that.
Berlinger's disbursements were
I said
going to third
Bacardi.
parties.
I said Bacardi, sir.
Let me ask this question.
Well, wait a second,
Whether the-
time out, he's out of time. Is there any way you can let him finish, because she's used up 0 time? She has a lot of time left. I don't want to have him stand up here for the next half hour, so do you have, is this like the last question you want to ask?
Last question I want.
Okay, fair enough. I'm with you.
The question of whether a writ of garnishment can reach a distribution made from the trust to a third party on behalf of Mr. Harris, is that just a question of the mechanics of garnishment law, or is there something in the trust code that I need to be concerned about on that?
Yes, Your Honor. First of all, Bacardi said that this right is limited to disbursements that are actually made to the beneficiary, that are due to the debtor beneficiary. That's what the case says. On page 29 of my brief, I'd also discussed the case of Zatkis, which says that the money has to reach the beneficiary. It could be under trust code, if you're only strictly looking at the Florida trust code, that a garnishment may be appropriate once it reaches a debtor beneficiary, and Bacardi says that this right.
Wait, now you're arguing. Did that answer your question sufficiently? You wanted to go on? I mean, is that good enough?
I'm good.
All right, it's good enough. You're done. Thank you very much. I'm going to give your opponent a chance to get her 5 minutes of rebuttal in. You ready?
Yes, sir.
Come to the podium, please, and finish up.
Thank you, Your Honors. I would just like to rebut stating that the DCF, which is supervising body over these SNTs, they must follow the standards of the DCF, which does state that if legal obligations exist, they exist and must be honored regardless of personal circumstances. In this case, valid orders for child support, the DCF does enforce child support and has a strong public policy about that. In addition, federal codes and state statutes which are followed by the DCF, state that if a legal conflict exists, that law, the more stringent one, applies. In this case, if federal law is more stringent, it takes precedence, or if state law. In this case, there is a strong support in both federal and state statutes and standards set by the DCF to pay legal obligations such as child support. So, I would like to, in conclusion, state that Mr. Harris did officially request his child support to be paid while competent, and this was brought up during the proceedings.
He was adjudicated incompetent in 2016?
Yes.
Okay.
So while competent, he did make formal
And
requests.
that's of record?
It was brought up during the evidentiary hearings.
Okay, well,
So-
all right. You said you were done?
And I would just like the court to vacate this order and rule according to what is deemed just and fair, and uphold public policy or current orders, including by this court, federal and state statutes, and the child support is valid, and garnishment is supported by law. So, thank you.
All right. I want to thank both sides, everyone, for coming. It's a challenging question. You can see we're interested in the outcome. Have a nice day. Safe journeys back.
Thank you.